Let's kick off with business and immigration law updates. This is a proud presentation of the Khurana Law Firm, where the Chief Attorney and Counselor at Law is Attorney Ramesh Khurana from Gaithersburg, Maryland. The moderator on hand is Attorney Kenneth Haber from Boyd's, Maryland. On this set, Attorney Haber questions Attorney Khurana on parents' green card petitions and challenges. Let's join these two gentlemen in their legal dialogue.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General of the United States Department of Health and Human Services. That's the Medicare cops. I am here to welcome Ramesh Khurana.
Thank you.
A world-renowned immigration attorney who has clients across the world and across this country, to the Capitol Forum. Welcome, Ramesh.
Thank you so much, Ken. I appreciate that.
Ramesh, I understand we're going to talk a little bit about the green cards today.
Sure. I'm a green card lawyer. I always love to talk about green cards.
Yeah, you get green cards for many people, I understand.
Yes, I do try.
Can't do it always, but often.
Yes.
Can a legal resident alien or green card holder file for a green card? Can you get them a green card?
Okay. So your question
For
is...
For their in-laws, for their parents, rather.
Okay.
Can you get that one?
First of all, for in-laws, nobody can file,
Okay.
whether citizen or green card holder. But if the question is about filing of a green card petition by a green card holder's son or daughter for his or her parents, not possible.
Even for you?
No.
Oh my God.
There are two eligibility requirements. Number one, you have to be a U.S. citizen before you can file for your parents. And second, you must be at least 21 years of age and over. If you are under 21, you cannot file either.
Well, that certainly shoots down, any thought of having a 100% scoring rate. It's precluded from the very beginning.
Right. So it doesn't become part of the scoring rate anyways.
Because it's
they are
not possible.
They are not eligible.
That's true. What's the difference between a consular processing and the change of status?
That's a very good question. Now, let us say a parent has come to the United States. He is on a visitor visa. He has been staying here for 90 days, 120 days, and he has changed his mind. And he says, I don't like to go back. I like the quality of life in the United States. I love to stay with my grandkids, whatever reason. There is a change of mind. And to begin with, his intention was not to apply for green card. He just wanted to come for the sake of pleasure, spending time with the grandkids and family and go back. But now with the change of mind, to answer your question, if he decides to file for green card, he doesn't have to go back. He can file for the change of status. We call it an adjustment of status application. That means the application is change my immigration status from a visitor visa to green card. So that is called the change of status while you are in the United States. And the consular processing is, okay, in this very example, a father decides to stay permanently in the United States, but he is not in a hurry. He wants to go back to his country. So the son or daughter files a petition for the father, and father goes back. The rest of the processing will take place overseas, where the father lives, whether it's India, Pakistan or Bangladesh, wherever. And he will come back when the application is fully processed and the father is given a green card. That is called the consular processing, means processing at the U.S. consulate overseas or at the U.S. embassy. That's the difference between the two.
I'm going to ask you which one is preferred and why, but I'm going to say something before that.
Sure.
When you were explaining that, the West Side Story came into my mind, and when you were saying that they decided they want to stay in America, and the theme song was "I Want to Be in America." Yeah, so that came to mind. But tell me, which one is preferred? Which processing is preferred, and why?
I would say that actually there is no preference. It all depends upon the circumstances of the case. Like I said, if you have changed your mind after living here for 60 days, 90 days, that means you can show that your intention was not fraudulent to begin with. Like you did not abuse your visitor visa for coming to the United States and applying for the green card. But your mind has changed now, and that's why you are applying for the green card. Remember, if you apply for when your stay is less than 60 days, probably you will be in trouble, because it's very hard to rebut the presumption of fraudulent intent. I have seen in my practice, if you apply after 60 days, that presumption is overcome. Like your intent was not fraudulent and you change your mind after coming to the United States and living here for 60 days. And the good thing is, when you file for your parents, now this doesn't fall within any preference category, the visa is current. And because the father or mother falls in the immediate relative category.
If a parent wanted to have you, let's say you're over 21, you're a U.S. citizen, you wanted to file for your parent for a green card, but in the meantime you wanted them to be able to come and visit. Is there any difficulties in that, and how to resolve that?
Again, it depends. What are the facts of the case? If you are already on a visitor visa and you have changed your mind, let's say that you are living in India, and you change your mind that you would like to convert into green card, that means your intent has changed. So that way you are abusing your visitor visa, because visitor visa is given only to those persons who have got non-immigrant intent. That means they do not want to settle in the United States permanently. So, as I said, if you change your mind while you come here and after that, let's say 50 days, 60 days, then that presumption is overcome. Everybody changes his or her mind over a period of time. That is not going to be held against you.
How do you resolve the issue concerning birth certificates if there's no birth certificate on record? Not every country has, digitalized birth records and records being mandatorily kept from, God knows how many years ago, like in this country. How do you deal with that issue?
I would say very well structured question. That's very true. While you are in America, you cannot even think about a situation where a person doesn't have a birth certificate. But it happens in many third world countries. But in India, if we are talking about India, now it's mandatory to record your birth with the primary governmental authority, which is responsible for recording births and deaths. But in good old days, there was no such requirement. Now, US government would like to see what is your birth certificate. If you think that your father's birth was not recorded, then you have to approach the municipal committee of that particular area where your father was born, and you should ask them to issue a certificate of non-availability of birth record. You have to obtain that certificate. Once you have obtained a certificate of non-availability, you have to support it with secondary evidence. What could be secondary evidence? Father's school certificate, father's governmental issued documents, like in India they issue Aadhaar card which has the date of birth, or they issue power to vote. Election Commission would issue some kind of ID. So you have to provide copies of those records. and Indian passport is also one of those documents which would be accepted as a secondary evidence, because it would have the date of birth, and this is a governmental issued document. And along with that, I would strongly recommend that you obtain 2 or 3, minimum 2, and if 3 are provided, that will be preferred. So, 2 or 3 affidavits signed by people with personal knowledge about the date of birth of that particular person. Then you meet the burden of providing the substitute documents for non-availability of birth certificate.
Very interesting. You got to be Sherlock Holmes in some
You know,
countries.
it has to be like that, Ken, because they want to see the relationship between the child and the father. And if the father doesn't have the birth certificate or the child doesn't have the birth certificate, child birth certificate is not available, it won't show who's the father.
Can they ever use DNA?
You know, it happens sometimes. If the evidence which is provided is not sufficient and RFE is issued, now they will give you the option. They will say, your evidence submitted is insufficient, provide us more documentation. At that point of time, you may decide that you would like to provide the DNA testing. That could be one of the strongest evidences. But otherwise, in some situations where they are suspecting the relationship, they can even ask, they do ask for the DNA testing. People don't like to see that, because first of all, it's very expensive, and second thing is they get frustrated, like thinking, oh, we have the father-son relationship, why they are asking us to provide the DNA testing? But it happens.
Do fingerprints ever come into play in terms of processing individuals?
Yes, of course.
And what happens if the fingerprints not legible?
Okay. Now, if fingerprints are not legible, that means USCIS cannot look to your background information like criminal records. Let's say father is visiting from India here, and because of age, fingerprints are not legible.
Now, we're talking about the original ones in the old country, right?
Right. So, even the officer at the application support center of USCIS probably was not diligent in taking those fingerprints effectively, and FBI is unable to process the criminal records. So, you come to know that your fingerprints are illegible. So, you may be asked to go to the state police in your state where you are living. But the problem comes, let us say you have been living in the state with your son for the last 3 months, but they need the criminal records for the last 5 years. So, in that kind of situation, they may ask you that provide us police report from the local jurisdiction and also the police report where you lived during the last 5 years. So, you have to contact the regional passport office back home in India and ask for the police report for the last 5 years. This is how this problem is going to be overcome. It becomes a little bit difficult.
What do they do if your sponsor, your son, say, his income, and he wants to sponsor you, and his income's below the poverty level? What effect does that have on things? Is there discrimination based upon income?
Not really, because US government is trying to find out whether you are going to be a charge on the state. So, income of the sponsor has to be 125% of the federal poverty guidelines, which are existing at the point of filing application. These change every year from July 1st. But it should not be the issue. If your son's income is not sufficient to support as per the poverty guidelines, then any other household member who is in the family, that person can also file the affidavit of support, or some outside friend or relative, they can also file. And interestingly, even the intending immigrant, let us say the father has come from Canada and he has $100,000 lying in CDs with Royal Bank of Canada, that evidence could also be provided by the intending immigrant to support that application. Only requirement is that these funds are readily available and these funds are repatriable. Repatriable means these funds will be transferred in case of need.
Well, I'd like to thank you very much for that explanation. I can see from the cameraman that we are running out of time, so I'd like to thank you, and I'd like to thank the viewing audience for visiting us at the Capitol Forum.
Thank you very much, Ken. Appreciate that.